His exact words were, "Mommy hit daddy in the face." The officer is doing his very best to communicate with this young child, and he asked this young child 6 times, and the child never wavered. He insisted.
Welcome back to Court Reacts. Heads up before we start. This is a domestic violence case, and we're going to handle it carefully. What you just heard is a defense lawyer in Judge McNally's courtroom in Downriver, Detroit, reading what a 3-year-old told a police officer on Bodycam. This is a bench trial, no jury, so Judge McNally alone decides whether the prosecutor proved her case beyond a reasonable doubt. Both sides get a fair shake here. Stephen Kennard is charged with domestic violence against his wife. She says he struck her in the arm. He says it was the other way around. There's audio, there's body cam, and there's a kid in the middle. Let's watch it the way the judge did from the very start.
This time, the defense would seek permission to make a motion for direct verdict of acquittal.
Go ahead.
Thank you, Judge. It'll be brief. Thank you. Your Honor, pursuant to Michigan Court Rule 6.419 AC, looking at a light most favorable to the prosecution without weighing the credibility of the witnesses, it is our position that the trier of fact cannot find that all of the essential elements of the offense of domestic violence have been proven beyond a reasonable doubt. Mr. Kennard is charged with domestic violence contrary to MCL 780.81 subsection 2. Number 1, pursuant to the criminal jury instructions, the people would have to prove that Mr. Kennard assaulted Miss Bonnie Stewart. Number 2, that Mr. Kennard is her spouse. Pursuant to the criminal jury instructions 17.2a, the essential elements would be, number 1, a battery is a forceful, violent, or offensive touching of a person or something closely connected with her. And number 2, the touching must have been intended by the defendant, and an assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit the battery or make the complainant.
So right out the gate, before the prosecution even calls a witness, the defense moves for a directed verdict. In plain English, he's arguing the state hasn't shown enough to even continue. They're looking at everything in the light most favorable to the prosecution. There's no proof of a forceful or offensive touching. His big point, the complainant admits no injuries, no medical care, no physical evidence. And he says the whole thing was caught on audio and video. Keep that in mind. The entire incident is on a recording. That's going to matter a lot by the end.
Reasonably fear an immediate battery. Your Honor, it is our position that the people have not met their burden. Factually speaking, and pursuant to the jury instruction, there is no evidence pursuant to 17.2a, there is no evidence of a forceful, violent, or an offensive touching on this record. The complainant admits to no injuries, no medical attention, no physical evidence of any touching, let alone a forceful, violent, or offensive touching. Your Honor, a forceful, violent, or offensive touching would have physical evidence.
Notice what the defense flags here. He says the complainant pointed to different parts of her arm at different times. The forearm to the sergeant, the tricep to the judge, and he points to a moment on the body cam where she allegedly tells the officer, "Please don't arrest me." Now, the prosecutor gets to respond, and this is where we stay fair. She reminds the court the state does not have to prove an injury, just an assault or an assault and battery. Fear counts. Let's hear her.
Any response?
Yes, Your Honor. Your Honor, when considering the motion for the directed verdict, the court must consider the evidence in the light most favorable to the prosecution. Now, defense counsel did just lay out the elements for domestic violence. So in this case, we do have to prove that an assault and or an assault battery occurred under the statute. And the prosecution did not need to prove injury in this case. And although we did not see any photos of injury, we did hear testimony about an injury. In addition, we heard testimony that the complainant was terrified of the defendant, Stephen Kennard, and he also saw body cam and police. The police started Canterbury's testimony that he observed Miss Stewart afraid and blinking and darting her eyes, indicating that she didn't want to be heard around Stephen Kennard. Again, under the statute, we need to prove an assault and or an assault and battery. And
You know what? I thank you very much. Taking all the evidence, like most favorable to the prosecution, the court finds that a reasonable fact finder could find proof beyond a reasonable doubt. There is still testimony as to whether or not the defendant battered the victim. There was testimony from the victim that she was struck in the arm. There is a dispute, obviously, with regard to where that would have occurred. I acknowledge that there were no injuries. However, an assault and battery does not require an injury. So I'm going to deny the defense.
And the judge agrees with the prosecutor on this motion. He denies the directed verdict. He says, taking the evidence in the light most favorable to the prosecution, a reasonable fact finder could find proof beyond a reasonable doubt, and an assault and battery doesn't require an injury. So the trial goes on. Important, denying the motion is not a guilty finding. It just means the state cleared a low bar to keep going. The real decision comes after all the evidence.
Cross?
yes. So, how long did you say you worked at, for the police department?
4 years at Woodstock.
And that's for Rosedale?
Yes, thoroughly.
And so I assume you had gone to, or done a lot of domestic calls in the past, is that right?
Yes, and I've done 7 to 8 years of police experience.
Is that total?
Yes,
And 4 years with Rosedale?
4 years, but
And when you,
Now we're in the body cam officer's cross-examination, and the defense is going after the most delicate part of this whole case. What the 3-year-old said, the officer admits the child volunteered on his own. Mommy hit daddy in the face. Let's listen to how that came out. And I'd ask you to hold judgment, because a kid this young is not a reliable narrator, and everybody in that room knows it.
you arrived at the home on Canterbury Street in Rosedale, is that correct?
yes,
And when you arrived there, you didn't talk to, a man named Steve Dunant, did you?
I don't believe so. I just don't remember if I helped with the handcuffing or anything like that, but I don't believe that I asked him.
And so you didn't take any statements from him?
No,
And you didn't take any statements from anybody buying Stewart that day?
no,
You went inside first, is that correct?
no. I went inside.
The officer's honest about it. He says a child can repeat things, but he wouldn't call it reliable. And the defense draws out that the officer asked, did daddy hit mommy first about 6 times? And the kid kept saying, mommy. But the prosecution's point lands too. The officer was leaning on a 3-year-old, asking leading questions, never confirmed it with an adult. Both of those things are true at the same time. That's the hard part of this case.
Makes me so nervous. Yes, at this time, I would like to call Mr. Kennard to the witness stand. From our perspective, Judge.
Okay. Raise your right hand, sir. Do you solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
All right, you may proceed.
I indicate your name for the record, please.
Stevie James Kennard.
And have you sat through the trial and heard the evidence in this particular trial?
Yes, I have.
Now the defendant takes a stand and flatly denies hitting his wife and says she hit him. Then his lawyer pulls out photos, bruises on his bicep, a cut on his finger, taken, he says, right after he was released. The prosecutor objects that there's no date or time on the photos. Fair challenge. The judge admits them subject to cross. So now there's physical evidence on his side of the ledger. Let's see the photos go in.
Did you hit your wife?
No, I did not.
Did your wife hit you?
Yes, she did.
Judge, may I approach
Yes.
the witness? You know, before I am approaching you with defendant's proposed exhibit number 4. 4, 5, 6, and 7. Defendants, can you identify what you see in defendant's proposed exhibit number 4?
That is my right bicep.
Okay, and do you see anything on your right bicep?
There's several bruises.
Okay, and can you describe for the court what you're wearing, that shirt that you have on there?
That's the shirt that I had on when I was arrested.
Okay, and when was this photograph taken?
That was immediately after I was released, back from the civil stand. Now I retrieved my belongings before my home.
And this photograph is taken inside of your home?
And here's the prosecutor's strongest counter on cross. If he was really the victim, why didn't he ever tell police he was hurt? Why didn't he call them? Why didn't he leave? Those are real questions. His answer: they were going through a divorce, still living together, and he didn't want anyone arrested. You can weigh that how you want. The point is, both of these people have a version, and only one recording can settle it.
Yes, sir. We have this. Sure, you have them. Well, that's okay. When I get out.
Okay.
So you were with Bonnie Stewart on April 3rd, 2026, is that right?
Correct.
And that day you had some kind of argument, not only with Bonnie Stewart, but with your ex-lady president in Ashley.
Correct.
And it was something about the custody of the children you have with Ashley. Right? And so around that time, you were pretty frustrated about this argument that you had with Ashley, right?
Correct.
And following that, you then began arguing with Bonnie Stewart, is that right?
Correct.
There was a point in time, if you heard from the testimony today, following this argument, you went upstairs to your bedroom, right?
Yes.
And you have a son with Bonnie Stewart, and is that right?
Yes.
And at some point he came to your room with some kind of ice cream sandwich.
Yes.
And you were frustrated and you kind of dismissed it.
Defense rests. Now we get closings, and I want you to hear both because the judge has to. The prosecutor goes first. Her case rests on the wife's testimony that she was struck, and the sergeant's observation that she looked afraid, eyes darting, scared to speak in front of him. Her argument, even with no injury, that fear alone can be an assault proven beyond a reasonable doubt. Listen.
We had two people in our case in chief testify today. We had Bonnie Stewart and we had Sergeant Canterbury. Your Honor, Bonnie Stewart had testified that the defendant, Stephen Kennard, had hit her on the arm once with an open hand. And the Sergeant Canterbury also testified indicating that he arrived to the residence. He saw that she appeared to be fearful and that he wanted to take her outside to get out of the situation based on his experience and knowledge that she appeared to be afraid to speak in front of Stephen Kennard at that time. And after that, he did speak to her and she indicated to him the same thing that we heard today, that she was hit on the arm by Stephen Kennard. We heard recordings, first recording made by Bonnie Stewart, where at the end you hear some rustling and you hear, "Why did you hit me?" At no point do we hear that she hit Stephen Kennard. At no point was a statement made like that to police. And at no point did Stephen Kennard say that he was injured. The domestic violence statute requires that an assault and/or assault and battery be made. It does not require injury. As you know, the definition for assault is for a reasonable person to be placed in fear of an immediate battery, and the definition for battery is for that forceful, offensive touching of another or something closely connected to that person. You know, we heard sufficient testimony today that she was placed in fear of, and she said herself she was terrified. She said she was terrified to even call the police in front of him. We saw a video and we heard from the officer of his observation that she appeared fearful. At the very least, an assault was proven beyond a reasonable doubt here, and we would ask that you find the
That's a real argument. Fear can be enough under the statute. Now the defense closing, and this is the heart of it. He leans entirely on the recordings. He says the audio shows she followed the defendant, refused to leave, said, "I want to be here with you," and then told the officer, "Please don't arrest me." And then there's the child on body cam. Let's hear the part we opened with in full context now.
I find more interesting than I have ever in all of my years is that the child, who is as sweet as pie and is innocent, volunteers to the officer and is captured on body worn camera. It was the defendant's admitted exhibit. He volunteers. His exact words were, "Mommy hit daddy in the face." The officer is doing his very best to communicate with this young child, and he asked this young child 6 times, and the child never wavered. He insisted that he was present when mommy hit daddy. And you know, Judge, I'm going to conclude this. Of course, I'm going to ask the court to find my client not guilty. But this is what troubles me, Judge, and I know it's Friday evening. Perhaps my client didn't have an audio or video recording of this particular incident. He might be differently situated. Perhaps Rose Hill Police Department didn't have body-worn cameras. He would be differently situated as he stands before the court. But in 2026, thankfully, there is audio and video evidence that we as defense counsel can provide to this honorable court on behalf of my client to show that not only is he not guilty of this offense, but he was the victim on that particular day. And as the court knows, he's not obligated to give any information to the police. When the police come to the scene on a domestic and you have a woman that's moving her eyes and the police don't know, they weren't there. They can only give the information as it is given to them and based on their own perceptions, based on officers' experience. Based on officers' experience, they did the right thing in arresting him. Did they do the wrong thing? Ultimately, absolutely, because he was the victim. And Judge, I'm not a man. But me and are macho. And so I can't see my client saying to the police, "She hit me on my arm," nor was he obligated to do so. The fact is that the court has admitted the evidence to substantiate that he was the victim on this particular day based on the photographic evidence that was admitted. And with that, Judge, I would ask this honorable court, I know the court has been listening and I can see that the court is taking meticulous notes and we appreciate the court. I would ask the court to find my client not guilty. Thank you.
So the defense's whole theory, in 2026, there's audio and video, and he says it shows his client wasn't the aggressor. The prosecutor gets one more word, and she makes a fair point right back. The defendant's photos came with no acknowledgement of injury to police at the time, and the officer was relying on a 3-year-old he never corroborated. Both sides have now said their piece. The judge has heard everything we have. Here's the ruling, and stay for the reason, because the reason is everything.
Briefly, Your Honor, in response to defense argument, again, the crux of the defendant's case is relying on the defendant and the officer Furtado. It's important for the court to consider the credibility of these two witnesses. First, the defendant submitting photos of injuries and even knowledge or any discussion of these injuries way after the fact. He had not told the police about any kind of injuries prior to arrest. He told nobody. There was no indication of him being in fear or of him being hurt in the recordings. And again, as for the officer, in his duties, not to deny the credibility in the course of his duties, but again, the credibility of who he spoke to. He spoke to a 3-year-old. He was relying on the narrative of a 3-year-old he never confirmed. the version of events that this 3-year-old had. And again, I would ask that you find the defendant guilty based off of the prosecution's evidence.
Thank you very much, both of you. All right, the defendant is charged with domestic violence. In order to prove this charge, the prosecutor must prove beyond a reasonable doubt each and every element of the crime. They must prove that this incident occurred on or about April the 3rd of 2026 in the township of Grosse Ile at 21615 Canterbury. Also, they must prove beyond a reasonable doubt that the victim and the...
Listen to what he's walking through. The elements, the presumption of innocence, and then the cracks. The wife pointed to her forearm to the sergeant, her tricep to the judge, her bicep to the defense lawyer. Same alleged hit, 3 different spots. The judge calls that what it is, an inconsistency. And he keeps going. The audio had no video. The defendant was recording. She said, "Stop recording me." And there were no visible injuries. He's not calling her a liar. He's saying the proof doesn't hold together beyond a reasonable doubt. Let's hear the finding.
Defendant were married at the time. At least that is the allegation. There are others that would qualify, but clearly they were spouses at the time. Prosecutor also must prove that either an assault or an assault and battery was committed beyond a reasonable doubt. A battery is the violent, forceful, or offensive touching of the person or something closely connected with her. The touching must have been intended by the defendant, that is not accidental, and it must have been against the victim's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended to commit a battery or to make Bonnie Stewart reasonably fear an immediate battery. An assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability to commit a battery, or must have thought he had the ability to commit a battery. A person accused of a crime is presumed to be innocent, and this means that that presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless the fact finder is convinced that each and every element of the crime has been committed beyond a reasonable doubt. In this case, the facts are really pretty straightforward. We have the victim testifying under oath that she was struck in the right arm by the defendant. According to the police officer, when asked at the scene, she pointed to her forearm. When the court asked her in questioning, she pointed to her tricep. When the defense lawyer was questioning her, she pointed to her bicep. That is an inconsistency. The entire recording that supposedly captivated this assault was only by audio. There was no video. There was rustling at the end, and the victim testified, "Why did you hit me?" She continued to stay there, and Mr. Kennard, and when I say there, I mean upstairs in the bedroom, and it was clear that the two continued to argue. Mr. Kennard kept telling her, "Go ahead and leave, take your pillow." But at all times, it was pretty clear to the court that the defendant was videoing the incident. The victim testified that she did not know whether or not he was recording the incident, but then again said twice, at least twice that I know of, "Stop recording me, stop recording me." There are other inconsistencies here. She claims that she was injured on the forearm. Like I said, she pointed to other different parts of her right arm, the tricep and bicep, and there was no visible signs of injury whatsoever. This is really, as far as I'm concerned, on top of that, and this is frosting on the cake, we've got a child here who's 3 years old that had just been scorned essentially by his father, in the sense that, and I don't mean scorn, but told, "I don't want this ice cream sandwich," and his feelings were hurt, and And the victim testified to that. And yet a few minutes later, she's telling the police, mommy hit daddy in the face. There's no contrary evidence to support anything other than the fact that this assault did not occur. She also stated, please do not arrest me. I don't know why somebody would say, please do not arrest me when they were the victim of an assault. So under no circumstance, honestly and truly, this is not a close call for me. There's no way the prosecutor proved her case beyond a reasonable doubt. You did a really good job, Ms. White.
Judge, I appreciate it.
And Ms. Holloway, you are going to be one remarkable lawyer. You've only been practicing how long?
Almost 5 years.
Well, you are going to be a really good lawyer. I love your demeanor, and I think you are going to be judge material. I find the defendant not guilty, and again, this is not really a close call.
Not guilty. And notice exactly how Judge McNally got there. He didn't say the alleged victim made it up, and he didn't say domestic violence didn't matter. He said the prosecution did not meet its burden. Too many inconsistencies, no corroboration, and recordings that didn't line up with the allegation. That's the whole job of a bench trial. The state has to prove every element beyond a reasonable doubt, and reasonable doubt is a high wall on purpose. He even took a second to praise both young lawyers, said the prosecutor will be judge material someday, firm but kind. That's McNally. Here's the honest takeaway. An acquittal means the evidence didn't clear the legal bar. It does not mean nothing happened, and it doesn't mean anyone lied. Domestic violence is real, it's often invisible, and most of it never gets a body cam. If you or someone you love is in danger, the National Domestic Violence Hotline is 1-800-799-7233. Free, confidential, 24/7. If this breakdown helped you understand how beyond a reasonable doubt actually works, subscribe to Court Reacts and tell me in the comments, based on what the judge saw, would you have ruled the same way? I'll see you in the next one.